the Constitution and the Federation of Australia. So the syllabus only gives us three things we need to know in the Constitution, and they're easily covered in this particular document. There's a lot more to understand. You go into deep depths around the Constitution. There are lawyers called constitutional lawyers who spend their whole time focusing on the meaning of different things with understanding the Constitution. We only need to understand three broad things. But to understand that, you need to understand the history, where we were before 1901 when the Constitution took effect, or the Federation took effect. And of course we had our Indigenous peoples going back 40,000 years. And then in 1788 we had the first European settlement in Australia. And they've hived off. I mean, they didn't really draw a map and draw the line down halfway, but for our purposes we can think about the colony of New South Wales. So this is a colony that's reporting back to the United Kingdom law, okay? And we think about it as taking up the eastern half of Australia. By 1825 we had Tasmania separately colonised, and we had Western Australia separately colonised, okay? 1851 we've got South Australia, this weird shape of South Australia, or leaves a weird shape for New South Wales, which is sort of like the leftover colony, if you think of it in those terms. And I think South Australia was in the 1830s, and then Victoria was actually in 1851. Okay, we split off Victoria. Then 1859 we have Queensland added on, and South Australia is expanded or reshaped, and then Queensland's added on. And you've got this weird thing, probably can't see the writing in that red space, but it's actually at that point in time in 1859 still New South Wales. So you've got New South Wales occupying two totally distinct areas, okay? The important or critical thing here to understand is that pre-1901 there's an Australian landmass, but there is no Australian nation. There are only separate colonies, each reporting back to the UK, okay? Of course they're communicating, talking to one another, but no actual nation, all right? Now the Constitution, 1st of January, came into effect 1st January 1901, is actually an act of the UK Parliament still, and there are three aspects, or I'll call them items, that we need to understand. The first is the separation of power. Any good democracy will have a separation of powers across three areas, and you can see them in the orange boxes there. It might be easier to look at the text down below in orange. So you see this text here, separation of powers, three boxes. We have the legislative body or power which makes the laws. Okay, in our case that's Parliament, federal Parliament, because we're talking about federal. We have the executive, which administers the laws. So you can see in the middle there that's the executive, and you see it says government departments down the bottom there, and includes the Governor General, but also includes, what's not in this diagram, includes the government ministers. So the ministers head up the government departments. So the Minister of Education heads up the Education Department, Minister of Defence heads up the Department of Defence, and so on. Okay? And then on the right-hand side, you've got the Constitution, the judicial power, which is the power to judge. And this is a critical, guys, this separation of powers is a critical component of, or aspect of, democracies. This is what you do not get in a tyrannical or dictatorship type environment. You don't get this separation. So to take extreme examples, for example, there was no separation in Nazi Germany of powers. And in Russian, around the same time with Stalin, there was no separation of powers. So you've got this dictator who basically holds all these powers, okay? And so the idea is, in a dictatorship we separate these powers. So I know that the person who administers the law, say the Department of Education makes a decision I don't like, then I can appeal it, and I'll have somebody independent who will hear that, either a court or tribunal. Okay, and we're going to talk more about tribunals later. You can just think about those for the moment as being courts. So this is the separation of powers, and you'll see in here the Parliament's divided into two houses, the Green House, which is a house of, and you see the green seats, House of Representatives, and the Red House, which is the Senate, and we talk more later about that, the operation of those two houses. Okay, but for the moment, the important thing to understand is that we have a separation of powers in Australia. It's not a perfect separation, and later on we'll talk more about why it's not perfect, but give you a hint that the government ministers are both in the legislative branch and also in the executive branch. okay? So it's not perfect, but look, it's pretty good. It's a separation that doesn't exist in some other countries, okay? The second item is the Constitution. The second item is the division of powers. I spelled Constitution wrong there. And that's tied back to those previous graphs we had, so that come 1900, the colonies had full power. So New South Wales had all its own powers. It looked after its defence, its quarantines, its immigration, its everything was because there was no Australian nation. Okay, so come the lead up to the Federation and the Constitution, there was this question of, okay, well, what power is the Commonwealth going to have versus the states? Okay, and the way that they did that was to end up with three different types of powers. So starting with number 2, there are powers that are exclusive to the Commonwealth. There's not actually a lot, as it turns out, but there's a couple in section 52, like the power to decide where the Parliament's going to be located. There's 114, which is defence, right? Defence of the nation, which obviously should be with the federal government. And 115, coinage, in other words, money or currency, is also with the federal government. Makes sense, right? Then there's number 1 is concurrent. Concurrent means at the same time. These are powers that the Constitution says can be exercised by the Commonwealth or the states, or both the Commonwealth and the states. So included in there is things like tax, marriage, customs, and so on. Okay, some of those things you look at these days and you say, oh, they really should be exclusive to the Commonwealth, but there's a difference here between theory and practice. In theory, those things can be done by both the Commonwealth and the states. In practice, commonly, the states have allowed the Commonwealth to legislate on those things and haven't interfered with that legislation. Okay, so marriage, for example, the states don't have any, as far as I know, at least in New South Wales and I think in all other states, there's no laws that have been enacted at the state level in relation to marriage. They've left it to the Commonwealth. Okay. Some students, so that's, and finally we have number 3 is the residuals. Everything that's left, everything else is left to the states, okay? So that includes things like health and education. The Commonwealth can still have an impact here through funding. So the Commonwealth generates most of the income, most of the taxes, or much more taxes than the states, and so has the power to influence what goes on through funding. They say, we'll give you this money if you do this, all right? So that's the division of powers. Some students get confused because the word separation, if I go back to separation and division, the words separation and division are the same sort of mean the same sort of thing. So the way I like to remember that is if you think about a map of Australia divided, where it divides the whole Commonwealth between, and it divides the states up on the map divides the Commonwealth and the states. So that's division of power. Okay. The third thing the Constitution does is it creates a High Court. So pre-1901, no High Court of Australia. There was no Australia, no Australian nation, right? So we have this new nation, we need a new High Court. So section 71 says, okay, we're going to create a new thing called the High Court. And within that division, or that part of the Constitution, it says the High Court can have 2 types of jurisdiction. Jurisdiction means its powers, okay? And if you look at number 2 to begin with, it can have appellate jurisdiction. So on certain matters where a senior or most senior federal or state court has made a decision, there can be an appeal made to the High Court. Okay. Now on most of these issues, the High Court can decide, yes, we want to hear this, or no, we don't. So it's not what's called a right of appeal, it's what's called special leave. The High Court can give leave to an applicant to appeal a matter, and will do so where there's a significant issue of law to be considered. Okay? And then the other one is constitutional-based issues. So by that, I mean if there's an interpretation, and there has been many over the years, if you look at the wording of the Constitution, you go, well, we're not quite sure what that wording means. Okay? And this is what courts do a lot. They look at statutes or the Constitution and they say, well, okay, you see those words there, it might be only 2 words like the external affairs powers in section 51. What do they actually mean in the context of a particular situation? Okay? And these matters, so that's one example, that goes straight to the High Court. Another example would be if a state was suing another state, or the state's or the Commonwealth's enacted legislation, the state disagrees, so the state's suing the Commonwealth. All of these matters must go directly to the High Court. They cannot go to any other court, and we call this original jurisdiction. And you can't see it, but that picture below the writing is actually a picture of the High Court of Australia, which is based in Canberra. Okay, but I can't scroll down there in this video. That's all you need to know about the Constitution, guys. We will delve in, when we go into Year 12, later in Year 11 as well, we delve in a little bit more into a few other things. This is, by the way, I said before, the Constitution, in the last video, I said the Constitution is both the foundation of our laws and also provides some laws. So to give you an example of that, these three items are really like the foundation of our laws. So you've got the separation of powers, the division of powers across the Commonwealth and States, and the creation of the High Court, right? And the powers of the High Court. But separate to that, we also have the Constitution providing some laws. So, for example, Section 116 says that the Commonwealth shall not impinge upon, and I'm paraphrasing here, but shall not impinge upon the religious freedom, okay? Rights of citizens to, or organisations to express their religious freedom. So this is an example of an actual law that the Constitution provides that they thought important to put in the Constitution at the time. And there are a few other examples of that. But mainly the Constitution is the foundation for all laws, as well as being the source of laws sometimes. Okay, yeah.